Hey guys, welcome to this video. I appreciate you being here. My name is John Watts. I'm a consumer protection lawyer in Alabama. And yesterday I put up a video about the CARES Act, which is this amazing federal law that was passed in March, and how it can help stop foreclosures if you have the right type of loan. And somebody put up a fantastic comment. It was, well, what if you're qualified under the CARES Act to receive the forbearance where you don't have to make any payments for 6 or maybe 12 months? And the mortgage company just says, no, we're not going to give it to you. And I thought, it's a great question, so let me do this video. So the title of our video is Suing Your Mortgage Company Under the CARES Act. And what laws can you use? What are the possibilities to be able to sue your mortgage company when you're entitled to a CARES Act forbearance, but your mortgage company will not give it to you? Now, you can also read this in written form if you go to sueundercaresact.com. And that'll take you to a particular page of our website, sueundercaresact.com. So here's what we'll discover. We'll do a quick review of the CARES Act related to mortgage forbearances. Now, we're not going to cover everything because you can just watch the video from yesterday. Then we'll talk about the FDCPA, the Fair Debt Collection Practices Act. How do we use that when a mortgage company wrongfully refuses to give us the forbearance? And then we'll look at RESPA, which is Real Estate Settlement Procedures Act, and RESPA letters, which are typically called a request for information and notice of error. How do we use those things? And then what about the FCRA, the Fair Credit Reporting Act? So how does this impact with credit reporting? And then finally, we'll end with some state law type claims. So quick disclaimer, I'm not your lawyer. Talk to a lawyer in your state if you're dealing with this. I'm licensed in Alabama. And the concept of this video is to give you some ideas. Not to say that all of these apply to you in your particular situation, but these are some things you can ask a lawyer in your state about and see if these laws can help you if your mortgage company is refusing to give you a forbearance when you're entitled to it. All right, so let's do a quick review of the CARES Act and when you have the right to a forbearance on your mortgage. So 3 things we need: federally backed loan, and remember that's FHA, VA, USDA, Freddie Mac, Fannie Mae. And we talked in the video from May 11th, yesterday, about how you figure that out. And then you have to actually request a forbearance. So it's not just that you're qualified, you have to ask for it. And then you have to truthfully tell your mortgage company the COVID-19 pandemic has impacted you financially. Now, I have this as the last point. All of this is assuming the CARES Act is still in force and effect when you apply for it. So it went into effect in March, and it will stay in effect for about 4 months after the president declares the emergency is over. Well, to my knowledge, he's not declared that, and that'll be some time, and then you add 4 months on. So if you're watching this during the time period the CARES Act still applies, then it's just those 3 requirements. You have federally backed loan, you request a forbearance, and you truthfully tell your mortgage company you've been impacted financially. Then your mortgage company must give you the forbearance. It's not optional. It's not recommended or suggested. They must give it to you. Well, what if they don't give it to you? Well, then look at the FDCPA, the Fair Debt Collection Practices Act. So we'll look at a couple aspects of this. Number one, we got to make sure it applies to us. So your mortgage company must meet the definition of a debt collector. We're not going to cover that because we do that in other videos, but I'll just say this. Most mortgage companies will meet this definition. Not all, but most people that we come into contact with, their mortgage company is considered a debt collector. Now, that's certainly something to ask a lawyer as you are looking at this. And then your mortgage debt must be considered consumer debt, so not business debt. So typically, this would mean you've taken out the home loan for a place to live in, not for rental property that you will rent out or just investment property that you're flipping. We're talking about this is where you plan on living. Okay. Now, here are some sections that may apply. So basically 3 groupings here. We have, these numbers are all the code section. So it's 1692D. That's when there's harassing or abusive conduct. Well, if you're entitled to a forbearance, your mortgage company won't give it to you. And particularly then if they foreclose on you, to me, that's pretty harassing or abusive. The next section is section 1692E. And that says to debt collectors, you cannot lie, you cannot be deceptive, you cannot hide the truth from people. So we have the general section E that just says that, and then we have some examples. So 1692E2 says you can't lie about the status of a debt. Well, if you're entitled to a forbearance and they refuse to give it to you, then I think that that is probably section E2. How about E4? Lying about you'll lose your home if you don't pay. Well, that's not true because you're entitled under federal law to this forbearance. Well, how about they say, we're going to foreclose when you're entitled to the forbearance? Well, that's lying about taking an action when it's illegal for them to do that. Or if they say you're not qualified and you really are, again, lying. About section E8, lying about credit reporting. So are they adding things to your credit report, adding late fees, property inspection fees? Are they putting a notation about you're in foreclosure when you really should be in forbearance? Well, then they know that that's false. They know that that's untrue. How about section 1692E10? It's just, look, there's a lot of overlap in these sections and subsections. It's just saying any use of deceptive means to try to force you to pay a bill, then that would violate this law. Well, remember, if you're entitled to the forbearance, that means you're entitled to up to 6 months and then an additional 6 months of not having to pay your mortgage. Now, eventually you have to catch up, but we're talking about for the next 12 months, you would not have to pay. So if they say you have to pay, then that's a lie. The final section, 1692F, and that has to do with being unfair. Well, if you're entitled to the forbearance and they say, no, we're not giving it to you, is that fair or is that unfair? Pretty sure that's unfair. Subsection 1 is collecting amounts not entitled to collect. Well, again, they refuse to give you the forbearance and then they say, we're hitting you with late fees, we're hitting you with property inspection fees, with foreclosure lawyer fees. Wait a minute, you're not entitled to do that. You violated 1692F1. And 1692F6 says, if they threaten to take your property when they have no legal right to do that, that would violate the FDCPA. So again, you're entitled to a forbearance, assuming you have a federally backed mortgage. You request the forbearance, and you can truthfully say, and you do say, hey, COVID-19 pandemic has impacted me financially. And they go, we don't care. We're going to take your house anyway. That would be a violation of the law. What do you get when you sue the mortgage company under the FDCPA? Well, you get compensatory damage. That's to compensate you. Another word for that is actual damages. So that could be economic. So say your house is worth $200, you owe $150. Instead of giving you the forbearance, they just take your house. Well, they took 50 grand of equity from you. That'd be economic loss. How about the emotional loss of facing a foreclosure, having your name published in the paper, or whatever the procedure is in your state? That would be very upsetting emotionally. Even if they don't foreclose, they just tell you they're going to foreclose, or they tell you they're not going to give you this forbearance when you're entitled to it. Well, now they're taking away something that you're entitled to, and that would be very upsetting. They have to compensate you for that. You can get what are called statutory damage. Statutory damages are where even if you can't prove you were harmed, you can still get it. It's only $1,000 total, but it's something. And that's where the government has said, we want to give you the incentive to file suit because we can't police all these debt collectors and mortgage companies out there. We need you suing the bad guys because that will get them in line. Now, going along with that, the costs that you incur, normally your lawyer would pay the cost, things like the filing fee and deposition costs and things of that nature. Normally you get that reimbursed by the mortgage company when you sue. And your attorney's fees, you would get that reimbursed. In other words, your attorney would work and, I'll tell you, our hourly rate's $500 an hour. So we work 10 hours, that's $5,000. Work 100 hours, $50,000. Work 1,000 hours. I mean, you get the idea. So, and that's not something that we charge our clients, but that's what the other side has to pay when we sue them. And we're successful in an FDCPA case. All right, what's another law? Well, RESPA, Real Estate Settlement Procedures Act. So what we're looking at is a servicer has to be subject to RESPA, and almost all of them are. Okay, so not all mortgage servicing companies are considered debt collectors. It depends on your particular debt, when it went into default. There's a bunch of factors. But almost every servicer is subject to RESPA. Okay? And again, we're not talking about, well, I took out this loan for an investment or a business. No, we're talking about you took out the loan to live there. Now, it's a little more complicated than that, but that's good enough for our purposes. Got to make sure RESPA applies. Well, what we're looking at here with RESPA is normally under RESPA, if you request loss mitigation, that's anything to prevent a foreclosure, which would include a forbearance, then your mortgage company must fairly consider you for that before it forecloses. Now, there's some deadlines in RESPA, so it depends on how close you are to the foreclosure and things of that nature. We don't have any deadlines in CARES Act. It's just you have federally backed loan, you ask for it, and you tell them you've been affected, boom, you get the forbearance. Now, when you've asked for relief that you're entitled to and they go, we don't care, we're going to go ahead and foreclose on you. That's called dual tracking. That's illegal under RESPA. So if you're entitled to the forbearance and they don't give it to you, and particularly if they go forward with the foreclosure, then I would sue them under RESPA. Now, the other thing you can do under RESPA is use these letters. They're called request for information and notice of error letters. And if you've ever researched anything about RESPA, you might have seen something called a QWR, Qualified Written Request. These are the new improved versions of a QWR. Okay? So here are some things to keep in mind. It has to be in writing. Okay? These are letters. They have to be in writing. And it's debatable. Can you fax them? Can you email them? You can do all that. But still, I would send them by certified mail or something else that will track delivery. So FedEx, UPS, whatever. If the mortgage company has designated a specific address to receive a request for information and notice of error, then you must send it to that address. You can look on their website. You can look on your statement, and it'll sometimes say, if you want to communicate with us, sending us a qualified written request, notice of error, request for information, send it to 123 Main Street. Well, that's where you have to send it. If you don't send it there, it's no good. Keep copies of what you send. Keep physical copies and digital copies. So put on Dropbox, Google Drive, whatever, but also have a hard copy printed and keep that in a folder. Make your letters simple, understandable. You want there to be no excuse for the mortgage company. You want when the mortgage company gets it for them to say, well, it's absolutely clear what they're asking. So I remember a time where we sued a mortgage company and we had done, I forget, probably 30 letters total. And they were saying, these letters are so confusing and we couldn't make heads or tails on them. That was their argument. So I get their person, what's called their corporate representative, who's swearing under oath in a deposition. And this person says, oh yeah, these letters are terribly confusing. I pull out letter number 1. I go, read that. I go, tell me what's confusing about it. Well, nothing. It's totally understandable. Okay. How about letter number 2? Well, no, that's totally understandable. We know exactly what you're asking for. And my point is, understand the mortgage company will lie, okay? That's just what they do. They'll say, we don't know what you mean by this letter. So make it so clear, so simple, so understandable that later if you have to sue, the judge is looking at them saying, what is wrong with you people? This was so clear. So let me give you some things to think about with a request for information. So that is where you are requesting information. And so think in terms of what we learned in high school English: who, what, when, why, where, how. So kind of start your sentences that way, start your letters this way. So it could be as simple as this: why did you refuse to give me a loan forbearance under the CARES Act? I want you to explain that to me. Now, you might put more detail in there. You might have multiple letters or multiple paragraphs in that letter. But the point is just very simple. It might be, do I have a federally backed mortgage? Did I make a request to you for a forbearance? Did I attest to you? That's the language in the statute. In other words, just saying that you agree this is true and it's accurate. Did I attest to you that I've suffered financially due to the COVID-19 pandemic? Why did you not give me a forbearance? So you're asking very simple, very clear questions that they can't go, well, it's kind of confusing. No, it's very simple, very clear. Now, a notice of error letter, that's where you're giving the mortgage company a chance to fix its errors. So you might say something like this: hey guys, you made an error in refusing to give me the forbearance under the CARES Act. Please correct this and fix any consequences. So late fees, inspection fees, credit reporting, if you advertise me in the newspaper about to have a foreclosure, are you going to retract that? In other words, whatever the consequences are, you're saying to them, I don't want you to just fix the error, but you got to fix the consequences too. Okay. So now again, you could have a ton of different notice of error letters. My point is just to understand the theory behind these letters. Okay? And then what do you get when they violate the law? And I'm not going to cover exactly how they have to answer those. We cover that in other videos, but the basic gist is they have about 30 business days, so you could think 42 normal days, to give you the information or to fix the error, whatever your letter is saying, whether it's request for information or notice of error. They also have to acknowledge within 5 business days receipt of your letter. But look, the point is, if they violate the law, what do you get? Well, very similar to what we talked about before, but with one major change. You get compensatory damages just like you do under the FDCPA. That could be economic, could be emotional. You get statutory damages when you can show a pattern in practice that they violate the law. Now, that could be a pattern in practice with you. So you sent them 10 letters and they ignored all 10 letters. Well, that's a pattern in practice. If you can show that for other people, they ignored their letters, they refused to respond, they refused to correct errors, great place to start, CFPB. Look on their complaint database. We have a video on that you can look up on our channel. When you can show pattern and practice, then it can be up to $2,000 per violation. Well, what if you sent them 20 letters and they ignored all 20 of them? That may be 20 violations. That's $40,000 in statutory damage, plus economic damages, emotional distress damage. And again, there's the incentive. This is why Congress passed this law, to give you the incentive to sue the bad mortgage company, because that's what will get them in line when it costs them more to break the law than it does to follow the law. So statutory damages, your cost, attorney's fees. Okay, how about the FCRA, Fair Credit Reporting Act? So here's some general thoughts on the FCRA. It requires accurate and complete credit reporting. That's the standard. Everything they report, it's got to be accurate and it must be complete. Well, the CARES Act says you're entitled to a forbearance when you meet the requirements. So if you meet the requirements and then the mortgage company puts a false balance on your credit report because they're adding late fees and inspection fees when none of that should be added because you were entitled to the forbearance, well, then that would be false credit report. What if they put a false status? They say you're in foreclosure when you should be in forbearance. Okay? What if you were 30 days late and you contacted them and you're entitled to a CARES Act forbearance and they won't give it to you, and then the next month they report you 60 days late? Well, that violates the law because that's not what the CARES Act says. The CARES Act says when you get that forbearance, they have to keep the same credit reporting during the length of that forbearance, or what the law calls an accommodation. Okay. So again, false status, false payment history, anything like that, that would give you the basis to challenge. Now, you must dispute through the credit reporting agencies. Let me say that again. You must dispute through the credit reporting agencies. A lot of people want to skip this step. I'm not sure why, but don't skip it. There is a part of the Fair Credit Reporting Act that says you can dispute directly to the furnisher. Your mortgage company would be the furnisher because they furnish information to the credit bureau, but you can't sue them for that. So they have legal obligations, but you can't sue under that. So you dispute under the, or through the credit reporting agencies, Equifax, Experian, TransUnion, those types of companies. They then notify your mortgage company, the furnisher, and say, hey, the consumer's done a dispute. Now there's liability on your mortgage company if they don't fix things. So here are some ideas for your dispute letters. Got to send them certified or the equivalent. So sound familiar to what we just talked about with RESPA. Keep a copy of what you send. Identify the account. So the credit bureau, so they know what you're talking about. Hey, this is my Mr. Cooper account. This is my Wells Fargo, my Ocwen account. Here's the account number. Here's the balance, or this is the only mortgage I have. Identify who you are. So your name, your date of birth, at least last 4 of your social, your address. Put in your driver's license. Get a recent bill. Cell phone bill, power bill, whatever. Just like the first page, it's got your name and address and a date. Or a statement, insurance statement, bank statement, just something to show the credit bureau, this is really you. Because the credit bureaus love to ignore disputes by saying, well, we don't think that's really you. But if you do your driver's license and you do a bank statement, now they may still do that. And if you sent them the information they need and they refuse to investigate, you may want to sue them because they've done a lousy investigation by doing no investigation. But look, identify who you are in the account. Explain the error. Okay? Don't just say, I dispute this account, investigate all aspects of it. Well, what's the credit bureau supposed to do with that? But instead say, hey, look, I was entitled to a CARES Act forbearance on this day. They refused to give it to me, and now they've added to my balance. They've added late fees. They've, instead of being 30 days late, they say now I'm 60 days late, or I'm 90 days late, or I'm in foreclosure proceedings, or whatever they put on there. Just be very, very specific so the credit bureaus don't have any excuse. And then when they send your letter to the mortgage company, your mortgage company has no excuse to say, well, we didn't know what you meant. And then request that false information be investigated, be corrected, or deleted. Again, make the letter simple. Okay, this is not the time for fancy language or try to impress somebody with how big of words you can use. Simple words, understandable, clear, so that there's no excuse. And send a copy to your mortgage company. Legally, it doesn't obligate them, but when they get that copy, they can't say, well, we were confused by what the credit bureaus were saying. No, they know exactly what you're disputing. Well, what do you get? You get compensatory damages. Again, actual damage, just like we talked about under FDCPA and RESPA. It could be economic and emotional. If it's intentional or reckless, okay? So they knew, or they should have known, that this was false reporting. Then you can get statutory damages. That can be $1,000 per violation. And you can get punitive damages. So far, this is the only statute that will allow us to get punitive damages. Punitive damages are to punish your mortgage company for doing bad stuff and to deter your mortgage company from ever doing this again to anybody in the nation, and to deter the other mortgage companies from ever doing this to anybody in the nation. In other words, the courts want to see when there's a punitive damage award, like let's say you get a punitive damage award of $250,000 against Mr. Cooper. Well, they want Ocwen to go, we saw that punitive damage award of $250,000 against Mr. Cooper. We don't want to get hit with that. And I bring up Ocwen because they were hit for, I think it was $500,000 in punitive damages. So point is, it's a very powerful law. And when you can show that they just have no excuse, it's not just that they are incompetent, okay, but they know that this is false credit reporting and they go, we don't care. Or we're not even going to investigate it. We're just going to assume we're doing what's right. We refuse to look at, well, that would be reckless or intentional. So again, you get your costs, you get your attorney's fees. Now, there may be some state laws that apply. You may have a state version of the FDCPA that applies to original creditors. Because remember, your mortgage company may not be a debt collector. It may be considered a, quote, original creditor. Well, you may have a state law that applies. So Florida has a Florida version of the FDCPA. Now, Alabama does not. Your state may. You may have a cause of action or a theory to sue under called wrongful foreclosure. So you're entitled to the forbearance. You asked for it. They refused to give it. Then they foreclosed on you. Well, they had no legal right. So you sue them for wrongful foreclosure. You may sue them for defamation. You may sue them for invasion of privacy. You may have a law. It's called different things, but basically it's described as deceptive practices. Maybe you can use that. Here's the point. You've got to look at all the possibilities under state law, whatever state you're in, because a lot of times state law will provide for punitive damages. Again, that's a big threat to these mortgage companies. Because look, here's what they do. They know they're violating the law. I mean, this is not a surprise to them. They know exactly what they're doing. But they say, you know what? We get sued under the FDCPA. We can't be punished for it. We get sued under RESPA. We can't be punished for it. It terrifies them under the FCRA. So they'll fight like the devil to get rid of your what's called intentional or reckless claims under the FCRA. State law, again, they're terrified of those punitive damages because they know when they have to start swearing under oath, I mean, these people are terrible when they testify because they're liars. Okay. And so when you get a liar and you can question them for 6, 7, 8 hours, they're going to get caught in their lies. Okay. Now, look, I wish nobody would lie when we depose them, but I'll tell you this, it makes our case so much better when these guys lie. They think they're so clever and they're just looking at us kind of smirking because they know they're lying and they know we know they're lying and they think they're cute. But what they don't know is we're building a case, we're painting a picture, and the jury can see that these guys are just absolute liars. And then if the jury who gets angry at them, justifiably angry at them, has the ability to do punitive damages, that's terrifying to the mortgage companies. So that's why they don't want you to have state law claims. They don't want you to have Fair Credit Reporting Act claims. I mean, they don't want you to have any claims, but certainly nothing with punitive damages. So look and see, do you have some state law claims? So if you want more help and you're in Alabama, give me a call, 205-879-2447 or alabamaconsumer.com. If you're outside of Alabama, find a consumer lawyer in your state who is familiar with foreclosure laws and the FDCPA and RESPA and Fair Credit Reporting Act, because you got to kind of put all that together here. And if you want to see the written article on this, again, just go to sueundercaresact.com and that'll take you directly to our article that we have. So appreciate you watching this. Definitely keep the comments coming. Any suggestions you have for future videos, we look at those, and if there's any way we can, we make those. So thanks a lot, and I'll catch you guys later. Bye-bye.